licensed immigration advisor.
Hello and welcome. I am Amanveer Jaspal. I'm a licensed immigration advisor.
We'd like to take the opportunity to talk to you today about the Immigration COVID-19 Response Amendment Bill 2020, which is being put before Parliament tomorrow and will most likely be passed on the 15th of this month. We've had a lot of queries, questions, people in distress trying to understand what is this, what is the bill, what does it mean for people onshore in New Zealand, for people offshore in New Zealand, and what changes are actually going to be there. What we want to help you understand today is why there are changes going to be made to the Immigration Act. What does it mean for you if you hold a visa for New Zealand and you're onshore, whether you're working, whether you're travelling, whether you're a student in New Zealand, and what also are the implications it could mean if you are overseas and you've already applied for a visa to New Zealand.
Yeah, so let us first briefly discuss why there is a need for such amendments to the Act. Immigration in New Zealand is governed under the Immigration Act of 2009. Under this Act, there are certain provisions that can be put in force if there is an epidemic or an emergency. But the reason why these additional amendments are being proposed is because the immigration minister feels that the enormity of the situation requires these amendments, and the current provisions of the Immigration Act are not sufficient to deal with them. So, just to give you a fair idea of the enormity of the situation that Immigration New Zealand is dealing with, I'll give you some figures. Currently, there are about 350,000 people in New Zealand who are on temporary visas. Out of that, there is close to about 200,000 or 2 lakh people, more than that, slightly more than 2 lakh people who are on work visas, temporary work visas in New Zealand. Close to about 78,000 student visa holders who are currently in New Zealand, and there are close to about 56,000 visitor visas holders in New Zealand. So a lot of these temporary visa holders would require some kind of amendments, allowing them to work for different employers, extensions, variation of conditions to the visas, changes and variations to student visa holders, visitor visas. So these amendments are required for them. That being said, currently the special direction powers with the immigration minister under the Immigration Act of 2009 are only available for case-to-case applications. The current provisions of the Immigration Act do not allow the immigration minister to pass special direction orders for a large certain group of people or visa category. So I think this is an important decision. One other important thing about these amendments are that they are time-bound amendments, so they will automatically lapse after a span of 12 months. So immigration ministry has put they have ensured that they have these safeguards and limitations on these amendments, and proper care has been taken to ensure that the migrants' interests are kept in mind. So
one of the amendments of the Act is the power to impose, vary or cancel conditions for classes of temporary entry class visa holders. Now, what does that mean? For an example, it could be to relax somebody's employment conditions. If you were there on a work visa in New Zealand and you are no longer working for one employer, it could relax the conditions to allow you to be redeployed to work for a different employer or even to work in a different location if they were conditions that you had on your visa. Another amendment is the power to vary or cancel conditions for classes of resident class visa holders. Now, this is important to understand. This would or could be used for extending the time frame for offshore resident visa holders that they have to return to New Zealand because, of course, at the moment, the world being at a standstill, these people are not able to enter back into New Zealand. So it would give the Minister the power to extend that time frame for when they could come back into the country. The power to extend the expiry dates of visas for classes of people, which means that the Minister would have the power to extend visa expiry dates for persons offshore who may not be able to travel to New Zealand within the validity of their visa. Another amendment is the power to grant visas to individuals and classes of people in the absence of an application. Now, some people may not be able to make an application because they are sick, so they cannot submit it. So this would give the Immigration Minister the power to still grant a visa in the absence of an application. Another amendment act would be the power to waive any regulatory requirements for certain classes of application. This could be to waive fees or other application requirements, for example, a passport picture or a medical, which they're not able to get at this time, to make INZ can then make more timely decisions, even if the absence of these are there. Another amendment is the power to waive the requirement to obtain a transit visa in individual cases. To waive a transit visa, this could be for diplomats and consular staffs returning to their homes, countries and transiting in New Zealand, or for individuals who have humanitarian reason to be transiting in New Zealand. Another amendment is the power to suspend the ability to make applications for visas or submit expressions of interest in applying for visas by classes of people. This means to suspend new applications for particular visa categories until global border restrictions are loosened and applicants are practically able to travel to New Zealand. We don't at this stage have any clarity on which visa categories may be affected. The last amendment is the power to revoke the entry permission of a person who has been deemed by regulations to hold a visa and have been granted entry permissions. This is mainly to prevent aircraft crew with deemed entry permissions who are not complying with the PPE requirements from entering New Zealand.
So, like you just heard these 8 amendments which are being proposed, which will be tabled in the Parliament tomorrow. Now, there's some questions that we have received from our clients regarding these amendments. So, first of all, I would like to just inform you that at this stage, no decision has been made on which visa category could fall under these amendments. So it's important for all of you to just wait and till official release has been provided by the Ministry of Immigration. I would also urge you all not to believe on WhatsApps and a lot of misinformation which is being floated around. It's important to also note that in one of the amendments, which is to suspend the ability to make applications for visas and to submit expression of interest. Now, this amendment is even also not, it's not a special direction. It goes above the threshold of a special direction, and to stop the applications for any visa category or expressions of interest, the Immigration Minister has to get approval from the Council of Ministers. So a proposal like that would have to be tabled to the Council of Ministers. And even if after it is approved by the Council of Ministers, such a restriction can only be imposed for a period of 3 months, right? So there are a lot of assumptions that the borders or applications will be closed for the year. We have the legal document with us, and very clearly says that even if there is a proposal like that, it would automatically be for a period of only 3 months. And just to just to suspend applications, it would require not just a special direction from the minister, but approval from the Council of Ministers. So I request you all to stay safe, be positive, and we will be coming back to you every day with whatever the latest updates are. And in the meantime, you can always write back to us, and we'll be there to assist you in all the ways possible. Thank you for watching us today.
Thank you.